The Supreme Court just made a decision about an important Second Amendment case, and now it's going back to a lower court. But there might be some problems with what the Trump Department of Justice is doing, and people who care about gun rights are watching closely to see what happens next. Let me explain what's happening with this case, because it's actually pretty complicated, but also really important for understanding how states can protect Second Amendment rights. The Supreme Court recently decided not to do an emergency review of a challenge to Missouri's Second Amendment Preservation Act. Even though they said no to the emergency review, this case isn't over yet. There are still things that could happen that might help protect Missouri's law, at least in part. You might remember that in this case, the Trump administration said that Missouri's SOPA law is invalid in some situations and that the Supreme Court shouldn't review it. But at the same time, the Trump DOJ also said that if the court denied the review, they would remove some of the total court order and injunction they got from the lower court. The administration told the Supreme Court that once the case went back to the district court, they would release at least part of that total judgment. This was supposed to be a compromise that would let some parts of Missouri's law go into effect. Missouri responded by saying that this promise from the Trump DOJ was actually a reason why the Supreme Court should review the case, because the Eighth Circuit's ruling would still stand even if the Trump administration removed part of the injunction. But after thinking about it in their conference, the Supreme Court decided not to review the case. It seems like the Supreme Court believed what the administration said and trusted that if they denied the review, the administration would remove some of that earlier ruling from the lower court. So maybe that's why they said no to the request. They thought the Trump administration would fix at least part of the problem. However, even months after that denial, the Trump DOJ still hasn't actually moved in the lower court to remove that complete injunction that was issued when Biden was president. This is where things get concerning for people who supported this law. The Trump administration made a promise to the Supreme Court, and so far they haven't kept it. This delay is making people wonder if they ever will keep that promise or if they were just saying what the Supreme Court wanted to hear. So what is this lawsuit about in the first place? It's about a 2021 Second Amendment Preservation Act that Missouri passed. That law stated how Missouri interprets the Second Amendment and put limits on how much the state would help federal agencies enforce federal laws that Missouri thinks violate the Second Amendment. The basic idea was that Missouri wanted to protect gun rights in their state and didn't want state resources being used to help enforce federal gun laws that they believed were unconstitutional. The law stops Missouri officers, agents, and government officials from helping federal agents who are trying to enforce those laws. So if federal agents wanted to enforce a federal gun law in Missouri, they couldn't get help from state or local police officers. The law also created a way for any Missouri resident to sue a Missouri official if that official helped enforce a federal law that the person or the state believes violates the Second Amendment. So the law was meant to give the real enforcement power to the residents instead of the state or its officers. Citizens could hold their own officials accountable if those officials helped the federal government in ways the citizens didn't agree with. In this case, the district court ruled in favor of the Biden administration, who brought the challenge, and they struck down the entire Missouri Preservation Act. They didn't just strike down parts of it or say some applications were invalid. They threw out the whole thing. Missouri then appealed to the Eighth Circuit and wanted a temporary pause on the lower court's decision, which eventually led them to ask the Supreme Court for emergency help. This was the first time the case went to the Supreme Court, and Missouri was hoping to get at least a temporary win. But as I mentioned, the Supreme Court issued an 8-1 order saying no to that emergency request. Only Justice Thomas wanted to grant the pause, which would have let this SOPA law potentially be used in some situations while the case continued. This was disappointing for Missouri and for supporters of the law because it meant the law couldn't go into effect even temporarily while the legal battle continued. After the Supreme Court denied the review, it went back to the Eighth Circuit, who held arguments and then ruled in favor of the federal government, striking down the SOPA law entirely once again. Then Missouri filed another request and went back to the Supreme Court for emergency review a second time. One of the big things Missouri pointed out was that the Eighth Circuit basically said the structure and potential operation of this law is valid, but they struck it down anyway because they didn't like its Second Amendment purpose. This seemed contradictory to Missouri. The court was saying the law could work legally, but they didn't like what it was trying to accomplish. Missouri argued that the Eighth Circuit went against clear legal precedent and decided that state officials could be sued because the court believed that the state played a role in enforcement just by following the state law. Basically, the court said that complying and not taking action was still enforcement, so Missouri was still responsible. Missouri thought this was unfair because they were arguing that not helping is different from actively interfering, but the court disagreed. This law was originally opposed by the Biden administration, but then the Trump administration took control of this case and all the others when Trump became president again. At first, the Trump DOJ delayed their response for several months at the Supreme Court level. People weren't sure what this meant. Were they reconsidering their position? Were they going to support Missouri's law? But eventually they submitted their answer, and it wasn't exactly what Second Amendment supporters were hoping for. In their response, the Trump administration continued to argue that the SOPA law was invalid and that the lower court got the decision right. This was disappointing because many people expected the Trump administration to take a different approach than the Biden administration. But at the same time, they said that if the Supreme Court denied emergency review and it went back to the lower court, the Trump DOJ would dismiss some of the total injunction they received, or really that the Biden administration received. This was at least something positive. They said in their response that after looking at this case again, they had concerns about whether the judgment goes too far and blocks parts of the law that are just the state choosing not to enforce federal law, which is protected under something called the anti-commandeering doctrine. This is an important constitutional principle that says the federal government can't force state officials to enforce federal law. They said these concerns were made worse by the uncertainty about how certain parts of the law would be applied and whether the parts the Eighth Circuit focused on are actually inseparable from the rest of the law. They stated that because of these concerns, they decided they would agree to narrowing the scope of the judgment when the district court gets control of the case again. So after delaying the case for a few months, the Trump DOJ responded by continuing to argue that some of the SOPA law is still invalid, but that the Supreme Court should deny review, and then once it was denied and went back to the lower court, they would potentially ask the lower court to remove some of that total injunction they issued before. Unfortunately, as I mentioned, the Supreme Court sided with the Trump administration in this case, probably because of that promise they made. The justices likely thought that if the administration was going to fix part of the problem voluntarily, there was no need for them to get involved. Despite that denial, this case isn't done yet and will still move forward. Based on what the U.S. stated in their request for denial, we would assume that once this gets back to the district court, they would fulfill that promise and submit some kind of release of that total injunction against Missouri's SOPA law. The bigger concern now is when will the Trump DOJ actually move for the lower court to remove that total injunction like they said they would do at the Supreme Court level. We'll now see if the Trump administration keeps their word or if they'll go back on that promise. But so far, a few months after that denial, we haven't seen any movement toward removing those complete injunctions. The Trump DOJ hasn't fulfilled that promise yet, which is very concerning for anyone who believed they would follow through. So unfortunately, the Supreme Court believed the Trump DOJ denied review of this case and denied getting involved in this issue. But there's still hope and potentially positive movement toward keeping some of Missouri's SOPA law in place. The case will continue in the lower courts, and there may still be opportunities for at least parts of the law to be upheld. But now we have to watch the Trump DOJ very closely to see if they keep that promise they made to the Supreme Court. That's what's currently happening in this important case, and as more information develops, people will continue watching to see what happens next.